Now I want to bring in Dr. Subramanian Swamy, Rajya Sabha Member of Parliament, joining us. Dr. Swamy, the court has literally drawn the Lakshman Rekha on this particular issue, saying that hijab is not an essential religious practice. But the fundamental point that I want to bring up with you, sir, is that many of these people are saying that, look, this militates against our right to choose.
Right. Well, everything is subject to reasonable restriction. Please understand, there is no fundamental right in the Constitution which is not subject to reasonable restrictions. And here, hijab wearing is only not allowed for a very small time, and that even on a daily life basis, only when you go to school. And you can wear the hijab at night if you like. You can wear it when you go to parties. You can wear it when you go to cinema. But when you go to school, everybody must look alike. And that is the part of the building of the equality of a feeling of equality amongst everybody, rich, poor, Muslim, Hindu, etc. So the hijab is being excluded as a reasonable restriction only for going to school. And how can they object? Yes. I don't understand. I think that if it goes to the Supreme Court, they probably won't even admit their special leave petition. They'll throw it out at the very outset, I think. Because there's no way they can prove that their fundamental right has been infringed unreasonably. They didn't prove it in the Karnataka High Court. I followed the proceedings.
Yes.
So therefore, I think they should give up this kind of fighting, because it only creates bad feeling amongst communities. And we think that all that is being asked for is that when you go to school, of course, if they don't want to go to school, no problem. It's up to them. But the fact of the matter is that if you're going to school, you have to look like everybody else.
You have to look like everybody else. And look, let me quickly break this down, viewers. Dr. Swamy is here and we have his wise counsel. The Holy Quran does not mandate wearing of hijab or headgear for Muslim women. Court goes through the Quran and its interpretations and comes out and says that the scriptures itself say it is recommendatory, not mandatory, viewers. The Holy Quran does not mandate wearing of hijab or headgear for Muslim women. It is very much here in this particular verdict. Whatever is stated in the above shuras, we say is only directory. Because of absence of prescription of penalty or penance for not wearing hijab, the linguistic structure of verses supports this view. Very, very crucial. The court has really gone into the minutiae here. This apparel at the most is a means to gain access to public places and not a religious end in itself. So this is also, which is very importantly been said, Holy Quran shuras are only directory. It is not a religious end in itself. Also, it goes into investigating this concept of where this hijab came in from. And this is what the court said. Hijab may have had something to do with culture, but definitely not religion. And there is a citation to support this. The court cites Yusuf Ali's note 3764 to verse 59, which runs as under: the times were those of insecurity, and they were asked to cover themselves with outer garments when walking abroad. It was never contemplated that they should be confined to their houses like prisoners. So that is also what has been put down. The court refers to triple talaq judgment and says what is made recommendatory by the Holy Quran cannot be metamorphosed into a mandatory dicta by the hadith, which is treated as supplementary stricture. In other words, what is only recommendatory cannot become binding on anyone. And again, this is a direct quote. Most importantly, Dr. Swamy, and I want to ask you this, because now, of course, there is being a move, and look, everyone is within their rights to move the Supreme Court. But the court has said that no material has been placed on record to show that petitioners have been wearing the hijab from the very beginning. No material placed on record to explain the undertaking that had been signed by the petitioners at the time of admission to the colleges and schools themselves, saying that they will adhere by the uniform. No sworn affidavit placed before the court by any Maulana explaining why hijab is an essential part of Islam. No material placed on record to show wearing of hijab is essential religious practice. And this has very many similarities to what you had argued in the Farooqi case in the Supreme Court when it came to masjids also.
I think mine is over, probably.
No, can you hear me? Dr. Swamy, can you hear me?
Hello?
Can you hear me? Dr. Swamy?
Yes, now I can hear you.
Yeah, so I was only asking you
Yes,
that no
yes,
material,
I can hear you now.
No material has been placed on record. No material. How will anyone go to the Supreme Court with what?
Yes.
With what fresh
Yes.
material?
Yeah, well, there are lawyers always who will encourage you to go to Supreme Court. if Mahatma Gandhi had laid down some, he was himself a great lawyer. He laid down some rules for lawyers. One of them is that if there's no case, don't please make them go to court. Explain to them, we'll be wasting their money. So I think it's about time for us to be very strict and say that the court has decided, and this is a constitutional principle. Common sense also says the same thing. We don't want them not to wear hijab outside the school. They can wear it immediately after they leave school, but inside the school they have to not wear the hijab. That's the rule. It applies to everybody. Otherwise, tomorrow somebody can say, I have a right to come in a bikini. Who can stop me? It's my fundamental right. Where do you draw the line? So this is, in fact, the thing that should clarify.
That should be clarified. Absolutely. Well, thank you, Dr. Swamy. Thank you for joining us this afternoon on what is a landmark verdict by a 3-judge bench. And we're being told it's a unanimous one. We'll, of course, confirm that also in due course.